Well, look at Federalist 80, Part 2. We got to paragraph 3, but before I go there, I've got something relevant to tell you, to share with you. I'm a very fortunate person. I had just started studying American history, and I'd come across the controversial work by Charles Beard, which I have mentioned his name to you before. He was one of the first ones that wrote a critical book about the founders and their intentions in 1913. I was very lucky because right around that time, I just read that book, I came across this book. It's a transcript of the conversations that Bill Moyers had done with a number of scientists, artists, philosophers, and political scientists. And one of these political scientists, or historians I should say, was Forrest MacDonald, who's written a number of books kind of refuting what Charles Beard had done. So I was very lucky that I came across that article when I did. This way I could expand my horizons and not totally follow what Charles Beard had said in his book. Plus, Bill Moyers, I think, is one of the true Americans. And if you get a chance, take a look at this book. I was very lucky to come across it in the Norman Library. There's a volume 2 of it. Very interesting conversations. It's wonderful. So wanted to give thumbs up to Bill Moyers and for these interviews. So let me read the Federalist 80 starting paragraph 3. I'm sorry. The first point depends upon this obvious consideration that there ought always to be a constitutional method of giving efficacy to constitutional provisions. What, for instance, would avail restrictions on the authority of the state legislatures without some constitutional mode of enforcing the observance of them? The states, by the plan of the convention, are prohibited from doing a variety of things, some of which are incompatible with the interests of the Union, and others with the principles of good government. The imposition of duties on imported articles and the emission of paper money are specimens of each kind. These are some of the things that in the Constitution has directly told the states that they cannot do any of these things. No man of sense will believe that such prohibitions would be scrupulously regarded without some effectual power in the government to restrain or correct the infractions of them. This power must either be a direct negative on the state laws, or an authority in the federal courts to overrule such as might be manifest contravention of the Articles of Union. There is no third course that I can imagine. The latter appears to have been thought by the convention preferable to the former, and I presume will be most agreeable to the states. As you remember from the first Federalist Papers, we said one of the main problems was the Confederation under the first Constitution of the United States had to always make requisitions to the states, and a lot of times they would not even reply. They would not honor the requisitions, any of that. So he says, we're writing this federal constitution, and as we have explained before, we want the law to be applicable directly to the people in the states. And because of that, as he has said before, he'd rather things get worked out in the courts by law, magistracy of law, he keeps on saying, rather than force, rather than having to send somebody to beat a citizen on the head for breaking the law. So he doesn't want brute force to be applied first. He wants reason, justice, courts of law to do the job first. And he says if we don't have these federal laws respected by the states, then nothing will happen. We won't have a efficient government. That's why we need a federal judiciary to oversee all these things independently and without bias. The next paragraph, as to the second point, it is impossible by any argument or comment to make it clearer than it is in itself. If there are such things as political axioms, the propriety of the judicial power of a government being coextensive with its legislative may be ranked among that number. The mere necessity of uniformity in their interpretation of the national laws decides the question. 13 independent courts of final jurisdiction over the same causes arising upon the same laws is a hydra in government from which nothing but contradiction and confusion can proceed. Still less need be said in regard to the third point. Controversies between a nation and its members or citizens can only be properly referred to the national tribunals. Any other plan would be contrary to reason, to precedent, and to decorum. The fourth point rests on this plain proposition that the peace of the whole ought not to be left at the disposal of a part. The Union will undoubtedly be answerable to foreign powers for the conduct of its members, and the responsibility for an injury ought ever to be accompanied with the faculty of preventing it, as the denial or perversion of justice by the sentences of court, as well in any other manner, is with reason classed among the just causes of war. It will follow that the federal judiciary ought to have cognizance of all causes in which the citizens of other countries are concerned. This is not less essential to the preservation of public faith than to the security of public tranquility. A distinction may perhaps be imagined between cases arising upon treaties and the laws of nations, and those which may stand merely on the footing of a municipal law. The former kind may be supposed proper for the federal jurisdiction, the latter for that of the states. But it is at least problematical whether an unjust sentence against a foreigner, where the subject of controversy was wholly relative to the lex loci, would not, if unredressed, be an aggression upon his sovereign, as well as one which violated the stipulations in a treaty or the general laws of nations. And a still greater objection to the distinction would result from the immense difficulty, if not impossibility, of a practical discrimination between the cases of one complexion and those of the other. So great a proportion of the cases in which foreigners are parties involve national questions, that it is by far most safe, most expedient to refer all those in which they are concerned to the national tribunals. We will continue with part 3 of the reading of Federalist 80 in the next video.